Hi, Tim Blankenship here with Divorce661.com, and the purpose of this video is to explain the process of setting aside a default. So let me set up the scenario real quick. So one of the spouses filed for divorce, 30 days went by, and it could have been 30 days or a year, and the default was filed. This is when the response is not filed. The petitioner will file a request to enter default, which basically pushes the respondent out of the case and can no longer file a response or participate. At least that's what it does in theory and practicality. However, there is a way to get around this. So if a default is filed against you, you can file what's called a request to set aside the default. There's a couple reasons you need to know about in order to do that. You have to file a motion with the court. It's a request for order, Form FL 300. And you also need to file your response. So this is how this plays out. The default's been filed, you want to file the response, you now want to participate, or whatever happened has changed and now you want to be a part of the case, but you can't file the response because the default's been entered. So you file a motion with the court to request the judge to set aside the default. You file the motion and you also file the response at the same time. So what you're asking the court to do is to set aside the default and to file the response at the same time. This does require a hearing. You have to file the motion, get a court date, serve the other party, and then appear at the hearing and explain to the judge why you think it should be set aside. Again, there are, I believe, 4 reasons why you can set aside a default. Just off the top of my head, one is surprise, meaning you weren't aware that it was going to happen or it could happen, and there's some other reasons. You have to generally do this within 6 months of the default being filed, so you can't wait 2 years and then say, oh, now I want to be a part of the case and I want to set aside the default. But just know, those are the rules. You have to file a motion, get a court date, you have to file your response at the same time, and generally what they'll do is they'll hold the response until the judge sets aside the default. And the reason I want to do this video today is because we just did a request to set aside default. We filed the motion, submitted the response with the filing fee check of $435, and I told our client the courts will hold that until the judge approves the set aside in order to file the response, because the court and the clerk cannot file the response if a default's been entered. So the fact that in this case the response was filed, I think, was a mistake on the clerk's part, because generally speaking, unless they've changed policies, which they couldn't have because the response couldn't have been filed, as I speak about this as I'm thinking, the clerk could not have filed the response with the default being filed. So in this case, I believe the clerk did make an error, but generally what will happen is you file your motion, and right now it's a $90 fee. You attach your $435 check to the response, and they'll hold it until the time of the hearing, and at that time, if the judge decides to set aside the default, then they will file the response at that time. Tim Blankenship, Divorce661.com. If you need any assistance with your divorce anywhere in California, feel free to give me a call, 661-281-0266, or you can always schedule a consultation right on our website at Divorce661.com. Have a great day.